thank you very much. It's a great pleasure to be today here with you in Iceland. When outside is dark and cold, and we will be talking about the topic that is, for me, it sounds very warm and bright, and really sounds very nice when you say child-friendly justice. And when I first heard that term, I really thought, oh, somebody really thought very carefully to come up with this nice wording, child-friendly justice. So if we can go to the next slide. I have to do it myself. Do I have the... I do it with this. Okay. Okay, great. Okay, so just to go through what is child-friendly justice. And of course, I won't be able in 50 minutes to cover everything what we were doing in the guidelines and the whole proceedings, but just to give you a notion, and then you can get inspiration maybe later on to ask some questions. So when we are talking about child-friendly justice, we are actually talking about justice systems which generate the effective implementation of all children's rights in the best possible manner, bearing in mind the following principles. And these are the principles that are basically coming from the Convention on the Rights of the Children: participation, best interest of the child, dignity, non-discrimination, rule of law. And doing that, we are giving the consideration to the child's level of maturity and understanding and the circumstances of the case. This is the justice that is accessible, age-appropriate, expeditious, adapted, and focused on the needs and rights of the child, respecting the rights of the child, and so on. So actually, when you look at the definition of the child-friendly justice that you find in the guidelines, it's a nice list of wishes, it's a nice declaration, and what is now very important is how really to implement this, that this really becomes a reality for children, because when we started to draft the guidelines, one of the things that we have seen, that there are many, many rights that are granted to the children, and actually when you are looking in the practice, that the reality doesn't look so nice as the stuff on the paper. And this is one of the reasons why Council of Europe has launched this project to draft the guidelines to somehow help to make these rights the reality. What's that? And I was asked 3 years ago to write an expert report before the guidelines started to be drafted. And I got a call and they asked me to write a report, since I'm a criminal law professor, on the protection of children as victims and the protection of children as perpetrators. And I thought, my God, who has given me that task? It's such a huge task. And they told me, and you have 10 to 15 pages to explain to us what we should do. So it took me like 3 or 4 months to think, how to draft that. And then I was even more surprised when I came to Strasbourg and when I saw that I'm only one expert. And then they have the expert from the family law area, from the administrative law area, and they have an expert on the human rights issues. And they said, we will put all this together. So we would like to have a guidelines that will tell us how to deal with the children in justice system. And I was thinking, oh, that's really very difficult. And if you are looking in the criminal law area, here you already have developed lots of rules and principles, but when you are looking at the family law area or more administrative law area, less and even more or less. So we have started, and it was really difficult, but what is nice about the guidelines is that they have this holistic approach. And I think that at the end, with all the struggles that we had, actually we came up with something that is really nice and that could work in practice and is applicable and it's helpful and so on. So you see, integrated holistic approach, as I said, they apply to all ways in which children are likely to be, for whichever reasons, and in whichever capacity, so as victims, witnesses, perpetrators, parties, brought into contact with the competent bodies and services involved in implementing criminal, civil, or administrative law, but not only that, in the proceedings that are out-of-court proceedings. So it's really kind of all-embracing. Custody cases, divorce cases, criminal cases, asylum cases, all of that. And the guidelines, what they bring declaration of principles, but they are also a practical guide. They are also a practical guide. So what we did, first, we identified the obstacles and challenges that children are facing when they encounter justice system. Then we tried to understand the children's needs, experiences, satisfaction or unsatisfaction with justice system. Then we evaluated existing programs and mechanisms that assist children, and we tried to find best practices around the world. Then we tried to find to what extent obstacles, challenges, and needs of the children are different in these different proceedings or in different capacities that children are coming in front of the justice system, and to see how we... And then, what is the ending? We try to identify the lacuna in existing international instruments dealing with the children and somehow to fill them also in. So for what do we need guidelines? We need them to ensure effective implementation of existing documents, because lots of stuff I didn't list for you, but it would be at least 5 pages of existing international documents which are dealing with stuff that guidelines are covering. Then ensure that rights developed for adults are equally applied to children, because often we forget that. Then to develop specific rights for children, if we see that something is missing, to fill in lacuna, as I say, and then, of course, what we always want to do in Europe, to harmonize the law so that basically we grant the same rights and the same or similar rights to children in different countries. Since I won't have much time, I will go and pass one slide, and then how the guidelines are structured. On the one hand, there are fundamental principles, and they define fundamental principles. And then on the other hand, they provide, as I said, these practical guides, general guidelines that are applicable for everything, and then guidelines how we should act before proceedings, during the proceedings, and after the proceedings. So the fundamental principles, I already mentioned them: participation, the best interest of the child, dignity, protection from non-discrimination, rule of law. And we put participation as the first principle, and we discussed a lot what should be the first principle. They are of equal importance, of course, but somehow what you put first says something. And we decided participation, not best interest of the child, not by participation, because it seemed to us that actually this is the beginning of everything, and that actually in practice we have the most problems with participation of the children. So how, right, I forgot my glasses, so I'm a little bit struggling when it comes to small letters here. So, right to speak for a child, very important. Right to give the views in all matters that affect the child. Then the obligation, participation entails in itself the obligation of the judges and of everybody who is participating in the proceedings to take into consideration the views of the child. And when they do not take into consideration the view of the child, to explain why they haven't taken the consideration, why they haven't taken that into consideration. Then what I said here is of capacity, so that we take into consideration the capacity of the child for the participation. What we find in some countries is that they set an age limit, and they say after that age the child is participating. Below that age the child is not participating. But we thought, well, yeah, that is a possibility, but maybe it's not the best possibility to do it. If we would like to ensure the participation, we should take into consideration the ability of a child, and the ability of a child should be judged in each particular case, and then it should be decided to which extent the child could participate. Then, best interest of the child. as another principle. And it was very interesting. We were reading the cases. There is some case law in front of the European Court of Human Rights. And it's interesting, and when you're looking at the case law of different states, how differently the best interest of a child is understood. And actually, it would be a great PhD dissertation, I think, for not only one, but few people to write about, how to understand the best interest of a child. Anyhow, best interest of the child has to be taken into consideration in each particular case, the guidelines say. In assessing the best interest of the child, multidisciplinary approach should be taken into account, and different experts should participate in that. When best interest of the child is taken into consideration, it always has to be balanced with interest of others, whether these are others' children in the proceedings or adults, but it has to be balanced. And there should be a comprehensive approach to the best interest of a child. So everything should be, in a way, taken into account. Legal aspects, legal interests, social, economical interests, and so on. So it has to be comprehensive. I won't talk about dignity. It's clear to everybody what is that. I won't talk much about the non-discrimination, but when we are talking about the children and when we are talking about non-discrimination, we particularly have to pay attention to two things. One is age discrimination, and it's not only age discrimination against adults, but age discrimination within the children, and discrimination related to the capacity. I have mentioned a little bit about that. The guidelines also are introducing the positive discrimination, which is today normal. So when we have especially vulnerable children, we could positively discriminate in ways that they need that. Rule of law is rule of law as we know it in the law in general, and all these principles that apply to adults should apply to children as well. But what is very interesting and what the guidelines are pointing out is that sometimes rule of law, when we have cases related to children, is neglected. And especially when we are coming sometimes to the cases, criminal law cases, that shouldn't be at all. And then often we deal with children out of justice system. We deal with children, for example, even in some social measures. And when we apply the social measures to children, then we apply sometimes very extensive measures without granting children the rights that we are granting to them in formal proceedings. And we should be very careful about that. So since I have not much time, I will just run to you to see what I am missing in interpreting. I have laid down the general the principles. Then, after that, the guidelines are dealing with general elements. So how you have to provide the information and advice, and what kind of information and advice you have to provide. Protection of private and family life. And yesterday Bragi asked us something which was very interesting and is related to your society, and it's when you have a case of a child and you publish the case on the internet, because you publish all the cases in the internet, how to protect the privacy. There are ways to do that. Safety, and special preventive measures for the children. Training of professionals, that all the professionals that are in contact with the children have to be specially trained. That we always have to give advantage to multidisciplinary approach, and there are some special provisions on deprivation of liberty. Hops, I'm talking about that. And then, when we are talking about the child-friendly justice during judicial proceedings, we are talking about access to court and to the judicial proceedings, legal counsel and representation, right to be heard and to express views, avoiding undue delay, organization of the proceedings, environment, child-friendly environment, and child-friendly language. And then we are talking about special ways of taking evidence when we have children in front of the court. And the last part, okay, I should go back. Oh, no, never mind, is child-friendly justice after judicial proceedings. And what should we do after judicial proceedings? Explain children, for example, the decision, provide treatment for children, issue of the disclosure of the criminal records and stuff like that. Thank you. So if there are some questions, I will be glad to answer them. Thank you very much.